before we get into the legal obligations of the debtors, it's what are your remedies? Well, you know, you can sue debt collectors that engage in illegal debt collection activities, but it's tough to get a lawyer to represent you in that. You want to find a lawyer that specializes in that because he knows the ropes and he'll go after them for you. But most lawyers and debt collectors know you're broke. That's why they're harassing you. You can't pay your bills, so you don't have money to pay a lawyer to go and sue them, and they know that, and that's one of the reasons why they routinely violate these laws. But there are some lawyers that will take these cases on contingency fee, and if you can find one of those, you can sue the debt collectors civilly. There should be more civil lawsuits against debt collectors because then debt collectors would back off and they would be less harassing. If you can't sue, you can report them to government agencies. Unfortunately, a lot of times the government agencies are pretty lax in enforcing the law. Although in California, you know, we live in that #1 business most unfriendly state in the union. We have pretty good enforcement against debt collectors if you turn them in to the state agency that enforces the debt collection laws. So, having said that, and talked about the legal restrictions upon what the debt collectors can and cannot do, what are your duties as a debtor? You have certain legal duties as a debtor. Okay, so #1, you cannot apply for credit if you don't intend to repay it or you know you don't have the ability to repay it. And one of the places where this comes up the most frequently is with regard to credit cards. If you have a credit card or you go out and get a credit card, just a few days before you know your business has failed or you've lost your job and you're going broke and you can't pay that back and you're going to file a bankruptcy and you go out and you charge on your credit card a bunch of luxury items or a vacation to Hawaii or something just before you file the bankruptcy, the credit card companies track the history of your charges. And if you run up some big charges in the month or 2 or 3 just before you file the bankruptcy, they may come into your bankruptcy proceeding and say, well, Judge, you can go ahead and discharge all of his other debts, but we're going to ask you we're going to file a complaint in the bankruptcy proceeding, and we're going to ask the bankruptcy judge to have our debt declared as non-dischargeable as obtained through fraud, because at the time the guy made these charges, he knew he was never going to be able to pay it back. He had no intention to pay it back, so it was debt obtained through fraud, and please declare it to be non-dischargeable. So be careful about running up a bunch of debt just before you file a bankruptcy or when you've lost your job or your business has failed and you don't have the ability or the intention to repay the debt. You must not knowingly submit false or inaccurate information on an application for a loan or credit. This one drives me nuts because of the amount of fraud that has been involved in the last few years, particularly among mortgage brokers, telling people, well, if you just misrepresent the amount of your annual income by this much more, then we can get you that home loan that you want. That was one of the other reasons for the housing collapse in 2008, was the amount of fraud that was going on encouraged by mortgage brokers and people, borrowers who didn't know better, were told that was okay. You can go to prison for making false representations to obtain credit. So don't do that. Don't let anybody talk you into falsifying a loan or credit application. Also, if the credit application asks you specifically about any adverse credit information, like have you ever filed a bankruptcy before, you must disclose the adverse information. If you conceal the adverse information, that may also be regarded as fraud. And now here's a funny one. Sometimes you have a line of credit or you have a credit card with a charging limit, and the lending agency will discover that you have some new financial problem. They see a pattern. Suddenly your credit rating has gone bad because you're not repaying a lot of your bills, or they find out somehow that you've lost your job. or something has gone wrong, and they will call you up and they will say, that line of credit that you have with us is now terminated. Do not make any further charges on that line of credit or on that credit card. Your credit card limit is now cut off. If they cut you off, but you continue to use that card or you continue to use that line of credit after they've cut you off, that is like stealing money, because it is taking credit that they no longer authorize you to take. So you cannot continue to use a charge card or write checks on a line of credit once the lender has cut you off. You have a legal duty to keep your creditors informed as to your current name and address and your employment status. So if you move out of state or you change your name, you can't do that to stiff your creditors. You have a legal obligation, as long as you still owe them money, to keep them informed about where you are and what your legal name is. So those are the duties that a debtor has to his creditors. And then the only other thing that we're going to talk about in this section on debtor and creditor is bankruptcy. So now we'll have a brief discussion of bankruptcy.